Hello and welcome to the intellectual property course on ePathshala. Today we are going to discuss a module on patents, traditional knowledge and biodiversity. This module pertains primarily to the relationship between patents and traditional knowledge, including biodiversity, and how each region either are in conflict or in complementarity with each other. In briefly introducing you to this topic, we are going to discuss what is traditional knowledge. We are going to discuss primarily some of the terms and some of the definitional ambiguities in traditional knowledge, along with associated genetic resources. We are going to discuss certain international measures in protecting biodiversity and traditional knowledge, primarily through the Convention on Biological Diversity and the recently concluded Nagoya Protocol. We are going to discuss the most contested TRIPS CBD relationship and how Article 27 of the TRIPS agreement requires patents to be granted on life forms. At the same time, there are certain exclusions that can be provided. Furthermore, Article 27 also requires review of the particular provision. We are going to discuss all of it in this particular course module. Some of the measures that India has taken to protect traditional knowledge, including associated biodiversity, and how both in terms of positive and misappropriation or prevention of misappropriation regimes are structured in India. We are going to study some legal frameworks. In this, we are going to study if a national legislation on protecting TK is essential and what are the steps taken by India, how other legislations like geographical indications or common law customary practices relating to secrecy, common law regimes like passing off can help to protect traditional knowledge to a certain extent and certain aspects of traditional knowledge. There are also measures within the patent system which allow interested people in preventing misappropriation of traditional knowledge by requiring disclosure. Also, we will discuss what are the key provisions in India's National Biodiversity Act and some certain measures taken by India relating to database protection through the Traditional Knowledge Digital Library. Now, what is traditional knowledge? Primarily, there is no structured definition of traditional knowledge, and as we are going to see in our next slide, this definition is ridden with ambiguity, but it is necessary to see what might constitute the important ingredients of traditional knowledge. Generally, it is understood as some essential piece of knowledge that is transmitted from generations to generations, or what is also called as intergeneration equity. It is constantly evolving, it is not static in nature, it is quite dynamic in that every generation or subsequent generations are free to evolve it and evolve the knowledge. In that sense, it is not static. It is also understood as some form of collective responsibility and ownership, generally that it belongs to the humankind, generally it belongs to certain indigenous populations as they collectively hold it, but it does not mean that traditional knowledge always and in each case must belong to an identifiable, must be identifiable with any indigenous community as such. It can be identified with particular individuals, it can also be identified with groups and a region as a whole or a nation as a whole and across nations. Similarly, it can either be open and closed in the sense that open forms of traditional knowledge would mean that the knowledge associated with the genetic resource is largely widespread and allowed to be used by large sections of the public. In certain cases, the traditional knowledge associated with genetic resources are closed in the sense that only a particular group or an identifiable group or individuals can use the piece of knowledge. Now, TK includes not just traditional knowledge as such distinct from associated genetic resources, but it also includes TKGRs largely in case of medicinal knowledge, but it necessarily need not involve medicinal knowledge as such. TK can also be apart from medicinal knowledge. In general parlance, the term TK has been broadly construed also to include cultural expressions like music, poetry, handicrafts, etc. So there are certain attempts to define traditional knowledge. WIPO, the World Intellectual Property Organization, has taken some leading efforts in conveying what is called as the Intergovernmental Committee on TK associated with genetic resources, and in one of those key negotiations certain provisions, certain definitions emerged Now, it has been defined in the broad sense of the term, which must generally include intellectual and intangible cultural heritage, practices, knowledge system of traditional communities, including indigenous and local communities. Now, this was in one of the documents called as the draft gap analysis produced by the World Intellectual Property Organization. Hence, TK in the general sense embraces content of the knowledge itself as well as traditional cultural expressions like folklore, including distinctive signs and symbols associated with traditional knowledge. If you look into international measures and how TK and TK associated with genetic resources to mean biodiversity evolved in discussions, it was during the Earth Summit in 1992 which first raised this issue on TK and biodiversity. In fact, Principle 22 is very clear to the extent that indigenous people and their communities and other local communities have a vital role in environmental management and development because of their knowledge and traditional practices. States should recognize and duly support their identity, culture and interest and enable their effective participation in achievement of sustainable development. Now, if you understand the import of this definition, it clearly does not use the word traditional knowledge as such, but it uses the word their knowledge and traditional practices and identifies it with indigenous people. Now, it is important to note that the CBD, Convention on Biological Diversity, and Principle 22 clearly relates all of this towards protection and achievement of sustainable development, protection of environment and achievement of sustainable development. Also, if we can recollect from the TRIPS agreement negotiations, these were not formally part of the Uruguay round negotiations which led finally to the TRIPS agreement and the WTO set of agreements. However, post the TRIPS agreement, these became part of the discussions on Committee on Trade and Environment. In fact, in early 1995, the WTO came up with certain documents within the Committee on Trade and Environment which clearly tried to narrate what might be the possible kind of relationship between TRIPS and CBD, and it stated that the Committee on Trade and Environment will consider the work program envisaged in the decision on trade and services and environment and relevant provisions of the TRIPS agreement, now as an integral part of its work. However, discussions in the WTO moved from the Trade and Environment Committee to the TRIPS Council by way of Article 27.3b review, which we will discuss in the later stage. Now, this review would require WTO member countries to consider how they are effectively implemented certain provisions relating to biotechnology or life form patents within their national laws, and it was in this context that discussions between a kind of conflict between TRIPS and CBD was sought to be discussed. Now, international measures pertaining to conventional biological diversity has three main goals. One is conservation of biological diversity, second is the sustainable use of its components of what constitutes biodiversity, and third is fair and equitable benefit sharing arising from such genetic resources. Now, if you look into the core of the relationship that is shared between biodiversity and patenting aspects relating to biodiversity, then the two key provisions that emerge is the prior informed consent and access and benefit sharing. Now, prior informed consent would mean that before accessing the resource, proper consent must be accrued through authorities, and access and benefit sharing would mean that those identifiable communities, and if not identifiable at least towards the state, the benefits that accrue out of commercialization of biodiversity must flow through. Convention on Biological Diversity also discusses access and transfer of technology, including biotechnology, to the governments and local communities that provide traditional knowledge or biodiversity resources. Now, these are not directly pertaining to access and benefit sharing in terms of monetary gains, but may involve transfer of technology requirements also. The Nagoya Protocol on access to genetic resources and fair and equitable treatment of benefits arising from the CBD, it specifically establishes a kind of framework that is required for predictable conditions to access to genetic resources, and also helping ensure how benefit sharing agreements and how benefit sharing of genetic resources between the contracting parties can be provided. The TRIPS CBD relationship has been discussed in the new context of emerging biotechnology tools. If you look into the last 30-40 years, what has happened is certain new tools in biotechnology like the recombinant DNA technology has allowed commercial utilization of nature and existing biological diversity without prior informed consent and access and benefit sharing. It means without any law, companies or individuals could actually, because of by virtue of use of these tools, use biotechnology and make commercial products out of it and put them in the market. Now these commercial products ultimately get patented if they are found to be inventive, novel and industrially applicable. Now example of such products are transgenic plants like the GM crops, transgenic animals like the famous Harvard OncoMouse, genes which are usually patented in terms of its information content although controversial, and genetically modified organisms. Now the TRIPS mandate in relation to protection of biotechnology products and processes is clearly laid down in Article 27. We have discussed Article 27 in the context of the provisions on TRIPS and public health. We would also briefly discuss it again here to understand the perspective from a biotechnology product or process. Any invention here within the framework of Article 27 would require to have an inventive step, novelty and industrial application. And as we know, what is the term invention has not been defined within the confines of the TRIPS agreement, nor is the term inventive step, novelty and industrial application. But it does not mean that WTO members have a kind of free will or carte blanche freedom to determine any definition by virtue of defining these terms, so that certain important biotechnology products and processes might be excluded. And it is for that reason that Article 27.2 and 27.3 clearly laid down the exclusion. The first kind of exclusion that pertains to certain biotechnology products and processes may involve exclusions based on ordre public or morality, and also those kind of inventions and the commercial exploitation of which would lead to serious prejudice to environment, human health and plant and animal life. Now it is important to note that under Article 27.2 you cannot reject inventions purely on the ground that the invention per se is harmful, but you have to take clue from the fact that the commercial exploitation of such invention would have certain consequences which are mentioned in Article 27.2. Clearly Article 27.2 does not lay down very important condition, but it definitely lays down the ground. You cannot reject it otherwise. The grounds that are mentioned in Article 27.2 must be carefully complied with by WTO member countries. Under Article 27.3 there are other important exclusions. Those that pertain to biotechnology are clearly mentioned in Article 27.3b. WTO members may exclude from patentability plants and animals. Now this was specifically negotiated during the TRIPS Uruguay round, wherein there was concerns that higher life forms, if allowed to be patented, are clearly unethical and it may have certain consequences. And this kind of exclusion was primarily because Europeans already had it in their laws. Essentially biological processes for the production of plants and animals are also sought to be excluded under Article 27.3b. Members shall however protect plant varieties through either patents or a sui generis system or a combination of both. Many countries protect plants through patents, many countries protect plants through sui generis system, like for example India protects through a sui generis system. But what do you mean by a combination of both is not clearly known. However, it says that plant variety protection must be effective. However, the model is not clear. What kind of a model would you require to provide effective sui generis or effective plant variety protection is not clear, primarily because there are primarily two international agreements. One is the UPA of 1978 and the UPA of 1991, which deals with criteria relating to protection and enforcement of plant varieties. However, countries like India have not been party to this. Neither the TRIPS agreement requires countries to implement the mandate contained in those agreements. So it is not quite clear as to how effective this protection must be, but generally countries have based the criteria for protection on the ground of that the plant variety should satisfy on the ground of novelty, distinctiveness, uniformity and stability. This clearly pertain to specific requirements of plants, because plants have certain characteristics that you need to show that they are uniform and stable and distinct over a period of time. There is no exclusion from patentability under Article 27. It means WTO member countries are required to protect microorganisms and non-biological and microbiological processes. Now, how do you construe microorganisms and what distinct definition would you employ for a microorganism is also not clear from the TRIPS agreement. Whether gene patents would be covered within the term microorganism, whether certain parts of animals which do not constitute animal as such or animal per se, would they be constituted within microorganisms, and how do you define the term of across jurisdictions is not particularly clear from the TRIPS agreement. Review under Article 27.3b is another important feature of this article. Under this article, there is a mandate to review the article and the implementation of 27.3 provisions. Now, this was primarily expressed as an important negotiating obligation during the Uruguay round, because there were concerns that certain countries who did not want to implement provisions on higher life forms, they may have things to say about their experiences post the implementation of the TRIPS agreement. So, by virtue of Article 27.3b, two important issues were sought to be raised later. Issues pertain to patent protection and under Article 27.3b and how countries have implemented, and how countries have also implemented the sui generis protection for plant varieties. Now, WTO Secretariat has conducted some wonderful information gathering exercise, and there are documents that pertain to how WTO member countries have implemented these obligations. The issue of conflict between the TRIPS and the Convention on Biological Diversity also became important during the Doha round, and paragraph 19 of the Doha Declaration specifically says that TRIPS Council should look into the relationship between TRIPS agreement and the UN Convention on Biological Diversity, the protection of traditional knowledge and folklore, and that the work of the TRIPS Council on these topics must be guided necessarily by the TRIPS agreement Article 7, which primarily deals with the objectives of the TRIPS agreement, and Article 8 relating to principles, and must take into account developmental issues that concerns the WTO members. Now, how this mandate has been interpreted is also interesting. Now, different countries have sought to bring in certain issues relating to TRIPS CBD conflict within the framework of Article 27.3b. However, there is no general common understanding relating to the nature of conflict between TRIPS and CBD, nor there is any common understanding as to how to find solutions regarding the same. However, there is some understanding that pertains to how TRIPS and CBD can be interpreted in a mutually supportive way. For example, either by exclusion of life forms totally. The TRIPS agreement Article 27.3 specifically requires you to protect certain kind of life forms, vis-a-vis the CBD obligations relating to sustainable development of traditional knowledge and indigenous and the rights of indigenous people. Now, how to require disclosure of origin, because disclosure of origin as far as certain developing countries are concerned has been one of the important negotiating challenges for them, or one of the important negotiating references. In Article 29, there is a requirement of disclosure. Generally, disclosure as understood within the framework of the patent law is a kind of quid pro quo, wherein the patent holder is expected to disclose whatever knowledge he is trying to seek a patent for. Now, and thus this disclosure shall be in the best mode possible, and it should be in the best mode possible as on the date of filing of the patent application. However, the developing countries are trying to seek an amendment to Article 29 by specifically requiring that patent applicants must mention in their patent application the source of origin of the particular biological material. This is also called as the amendment to disclosure requirement. And by virtue of this, developing countries think that they can achieve certain reasonable degree of certainty as to whether these patent applicants have actually taken the information, the traditional knowledge associated with biodiversity by requiring prior informed consent and access and benefit sharing. Now, there is also thinking as to the nature of conflict between TRIPS and CBD might relate to the grant of erroneous patents. Because patents are allowed on life forms, certain member countries believe that patent system might lead to grant of erroneous patents, and they frequently cite examples like the turmeric. This turmeric example is pertinent because America prior to 2011 had a requirement under its patent law wherein novelty in relation to public use would be only local. So basically, prior public use in relation to any biological product would be construed within the territorial boundaries of the United States. This was prior to 2011, and due to this, what happened was the properties of the turmeric, the antiseptic properties of the turmeric, were sought to be patented in one of the applications filed by 2 Indians in the United States, and USPTO granted them. Later, the government of India had to engage experts to get the patent revoked, and finally the patent was revoked. Now this example is frequently cited to suggest that the patent system, when not effectively tailored to the requirements of prevention of misappropriation, may indeed and actually lead to misappropriation. It is also important for some countries to look into how patent offices can gather more information to prevent erroneous grant of patents, and to see that traditional knowledge is not misappropriated, or traditional knowledge associated with biodiversity is not misappropriated. Now there are examples that countries have tried to implement, like China and India have databases on traditional knowledge. Coming to India, India does not have a law on traditional knowledge which provides positive rights based protection, in the sense that India does not clearly say that the holders of traditional knowledge shall have the right to protect their TK as such. However, we have legislations relating to the national biodiversity which to a certain extent protects the TK against misappropriation, and which would also require fair and equitable benefit sharing, including prior informed consent, and certain rights of TK holders have come to be recognized through the National Biodiversity Act. Currently discussions are ongoing on passing a law on TK. However, there is strong lack of consensus. There was a draft copy of the bill that emerged, but nothing further has been discussed in relation to positive protection to be made available to traditional knowledge. Indian experience with the traditional knowledge digital library has been unique, and we will also study towards the end the importance of having a traditional knowledge digital library, including its important limitations. The Biological Diversity Act probably is one of the most important acts that was legislated in 2002 in relation to protection of biodiversity. Both prior informed consent and ABS based on knowledge or resource obtained from India is required. So National Biodiversity Board, that is a federal level board, governs access by foreigners, and the State Biodiversity Board regulates access by Indians or Indian companies. Now the benefit that flows may directly go to the indigenous communities or individuals or to the National Biodiversity Fund. Wherever individuals or indigenous groups are not identifiable, then it shall go to the National Biodiversity Fund. Apart from the monetary gains, the legislation requires that if by virtue of contract between the parties there can be a grant of joint ownership of IPRs, transfer of technology may be required, association of some Indian scientists in the research and development may be required, and setting up of venture capital fund, etc. may also be required. Now there is also a requirement of people's biodiversity registers. As I mentioned to you, more and more information relating to traditional knowledge associated with biodiversity and creation of such information leading to a grant of avoiding the grant of erroneous patents is important. So what countries like India have done is they have come out with what are called as people's biodiversity registers. These people's biodiversity register basically try and locate the traditional knowledge within the territorial boundaries of the states, and then can try and document them. Now they have some of the states have gone ahead and have opened up these people's biodiversity registers. What is important to understand is that we clearly do not know who is going to have access, and whether the access will be given by virtue of a commercial value. Under section 65, government has been obligated to protect TK in relating to biodiversity through measures such as registration or sui generis protection. However, as mentioned, India has not still implemented these obligations in relation to positive form of protection for TK. However, draft protection, conservation, effective management of TK rules have been there for some time, the 2009 draft, but it is not enforced as yet. So there is a significant role for TK holders in decision making process in this particular draft. Prior informed consent and how TK representatives would be selected is in this case is not clear. The Patents Act is one of the important pieces of legislation that allows you to create a kind of a framework that can avoid misappropriation of traditional knowledge and associated biological diversity. Most important is section 3p. Here an invention which in effect is traditional knowledge or which is a mere aggregation of or duplication of certain known properties of traditionally known components, such kind of inventions will not be granted a patent. Now it is very interesting to see what happens if the novelty aspect, the inventive step aspect and the industrial application, these three criteria that constitute an invention are qualified, and yet section 3p would exclude certain kind of inventions, primarily because this kind of invention is an aggregation or duplication of known properties of traditionally known components. So it thus becomes important that you don't just have a layer of subject matter exclusion, but you also have a layer of patentability thresholds and a higher level of patentability threshold to prevent misappropriation. Section 3b, which discusses something similar to article 27.2, wherein patents may not be granted on inventions which primarily the commercial exploitation of which leads to ordinary public and morality crisis, and which may cause serious prejudice to plant, animal or human life. This provision has not come to be interpreted through any kind of appellate court judgment, but suffice it to say at this moment that the commercial exploitation of the invention must lead to certain kind of consequences that are mentioned in section 3b. Furthermore, section 3j discusses certain biotechnology exceptions. Now this clearly implements the obligations that are required under article 27.3b, wherein member countries are free to exclude plants and animals and essentially biological processes, but they may not exclude, for example, microorganisms and non-essentially biological processes, including microbiological processes. So in this case, section 3j of the Patents Act excludes plants, animals, including parts thereof. Now how the interpretation of parts thereof must lead to certain kinds of exclusions of biotechnology material is not particularly clear. Under section 10, which requires patent applicants to disclose their patented invention, their applications pertaining to biological material should disclose the source and geographical origin of the biological material. This is an important requirement under section 10 of the Patents Act. Similarly, this has been clarified, and how this has to be done is clarified under form 1 under the patent rules. And under form 1, you would require declaration by an applicant that the biological material used was from India and that it has obtained prior permission from relevant authorities. Now the source that I have taken from Anuradha RV suggests that there is no evidence of Biodiversity Act permission, however, required. It means you need not go and get a specific certificate or a requirement from that is not clearly a requirement under the patent law. But what is the legal effect? Ultimately the legal effect is revocation. A patent may be revoked both under section 64 and 66 if it does not comply with the disclosure norm under section 10. Now this revocation is kind of interesting because under section 64 you can revoke on all the grounds that pertain to patentability, including lack of novelty, lack of inventive step, lack of industrial application and lack of disclosure. At the same time, section 66 goes one step ahead and allows governments to revoke the patent purely on the ground of public interest or that it is mischievous to state. Now provided you give an opportunity for hearing. There are two examples primarily that lead to revocation under section 66. One of them will be discussed today, that is Evastogen patent. Now this particular patent was filed by an Indian company called Evastogen relating to the anti-diabetic properties of jamun and other fruits, and these patent applications were not opposed, interestingly, by any groups, including the CSIR. However, CSIR had opposed the same patent application filed in the European Patent Office, but it did not oppose the application, the similar application that was filed in India. So the patent was granted in India, and then later when this patent was noticed by government officials, they sought revocation of the patent through the utilization of article section 66, and the reason primarily given is because it pertains to traditional knowledge as such and does not involve anything more than traditional knowledge. So this is clearly an example of use of article 66, where clearly prior to the grant or even after the grant, there was no pre and post grant opposition at the patent office, and no one challenged the patent for revocation. So it was the bounden duty of the government to revoke it, primarily because it was aggregation of traditionally known components and it essentially formed traditional knowledge. Another way to protect certain aspects of traditional knowledge relating to plant varieties is through the Protection of Plant Varieties and Farmers' Rights Act 2001. Under this legislation, benefits can be claimed by those indigenous tribes and communities wherein their genetic material is used in the development of a new variety. So whoever produces new variety based on earlier varieties wherein certain traditional knowledge or certain other aspects of biodiversity is involved, then the earlier originator would be required to be compensated. So it is something certain kind of a benefit sharing requirement that is under the Plant Varieties Act. Similarly, farmers would always have the right to save, use, resow, exchange, share or sell his farm produce in relation to non-branded seeds. Now this requirement specifically allows farmers to get certain kind of protection against infringement of plant varieties. Farmers can also register their own varieties. Now this is a kind of positive protection that the law provides to farmers, wherein their own varieties which is based on certain existing traditional knowledge can also be registered. Geographical Indications Act 1999 is one of the new legislations that is required to protect certain aspects of brand relating to relating to products that have certain attributes which can be traced to a geographical location. Now geographical indications as such and per se may not provide full protection to traditional knowledge and products associated with them, but it definitely helps them to protect the unique name symbol of the product in which the TK persists. Now this may be suitable to a limited extent, since GI acts as an authenticity quality of the mark for quality reputation characteristics of the product. It is a kind of collective property philosophy, and hence it acts in a way to protect certain elements of the collective property notions involved in traditional knowledge. Now applicants can be any association or producers and must represent the interest of the producers. Now this is a kind of unique law that can protect certain aspects of traditional knowledge. The common law regime of passing off can also be used in certain circumstances where products based on traditional knowledge are actually misappropriated and used, wherein the other person who infringes on the mark or on the name would sell it as arriving from the source of others, in the sense that he would sell it primarily to show that it originates from the person who has originally produced the product based on TK. This remedy is even otherwise available in case of other kinds of infringement of unregistered trademark, which can be extended to the products that involve traditional knowledge too. Similarly, the scheduled caste, scheduled tribes and other tribal forest dwellers Recognition and Forest Rights Act 2006 grants legal recognition of rights to traditional forest dwelling communities in relation to certain kind of biodiversities. Now this is a very important act which pertains to forest dwellers and their traditional rights relating to collecting of forest produce. Finally, India has come out with what is called as a traditional digital library, traditional knowledge digital library. In this case, measures are taken to prevent misappropriation of traditional knowledge, and what happened was, after the turmeric and the neem episodes wherein patents were wrongly granted and subsequently revoked by USPTO, it was thought by the Indian government that it would be important to document these and create a wide repository of existing knowledge and create it in different languages, so the different patent offices can use those libraries and can either revoke the grant or may not grant based on the existing prior art that is mentioned. So primarily the TKDL is translated in several languages: English, German, French, Japanese and Spanish. Traditional knowledge resource classification is a standard taxonomy that is used for classifying these. TKDL covers over 2 lakh formulations which have been taken from Ayurveda, Unani Siddha and Yoga text. Now this project is quite impressive in the sense that a lot of existing material has been located and translated into identifiable text. Now the PLIDED project, and it's clearly not a comprehensive documentation of traditional knowledge. However, excess MOUs have also been signed with the EPO, JPO and USPTO. Now this traditional knowledge digital library is held in confidence and is not clearly available to the larger section of the public, but special access agreement are granted to EPO, JPO and USPTO and some other patent offices. Free access to patent offices has been criticized by a lot of people because the collection of these resources and documentation involved a substantial amount of money of the Indian government. Furthermore, free access has also been criticized on the ground that it does not factor in the actual knowledge that is already ingrained in relation to TK associated with biological resources. One other important aspect in relation to traditional knowledge digital library is that there is no effective mechanism to prevent leakage. Now these databases, although are granted through MOUs and access agreements, but whenever a patent applicant has to make an application in relation to a biological resources, and if certain certain description mentioned in the invention somehow overlaps as part of prior art that is mentioned in the TKDL, the patent offices will require to give reasons for rejection, and in providing reasons for rejection the patent offices may actually use and transmit the knowledge from the TKDL library and mention them as reasons for not granting the patent application. So ultimately the constituency, that is the patent applicant, gets hold of this knowledge by virtue of certain reasons that are cited in the rejection letter or the reasons that are mentioned by the patent offices for not granting the particular patents. So widely, TKDL has been used to a certain extent, but there is a whole lot of potential for abuse also. So with this we conclude this module on patents, biodiversity and traditional knowledge, including we have studied how it is difficult and ambiguous to define traditional knowledge as such and the attempts at the WIPO to define traditional knowledge. We have also looked into what is the requirement under Convention on Biological Diversity, how does it view traditional knowledge and how does it view the rights of indigenous communities, what does Nagoya Protocol deal with and how access and benefit sharing mechanism is clearly outlined in the Nagoya Protocol, what are the particular kind of conflicts or complementarities within the TRIPS and the CBD, and finally we also discussed Indian provisions through various legislations as either in relation to positive protection of traditional knowledge associated with biodiversity or in relation to misappropriation of traditional knowledge associated with biodiversity.